know that you probably aren't actually. So I completely understand. I have known after having done presentations for 35 years, that most people who are happy about one of my presentations are close to retirement, especially special ed directors. So I totally, I wanted to just start by saying that, wow, what a challenging year we have had, right? I will say that having done this 3.5 decades, I've never been more proud than to do the work that I do, and that is to work with those who are devoted to educating students with disabilities, whether it's at the district level or the state level. I have represented school districts and state agencies for as long as I have been a professional, and I have seen such dedication over many, many years, but nothing like I saw in the last year. And though I admired it, I admired the response to the challenge, I don't want to do it again. And so we are seeing a light at the end of the tunnel. I certainly hope you guys are in Mississippi. We're neighbors. I live in LA, Lower Alabama, here in Mobile. So I'm always really excited to be with my neighbors in Mississippi. So we have what I call lightning speed presentation, and I had to do my breathing exercises this morning because this slow talking Southern girl has a hard time getting through 90 tips in 120 minutes, but I plan to get through every single one of them. You should have access to a handout that I created for you called, obviously, 90 tips in 120 minutes. It's quite lengthy, but it has a lot of support for every single one of these tips that I'm going to talk about. Now, some of these tips sort of speak for themselves, but they're all based on my 35 years of working with schools and making sure that we stay out of what I call deep doo-doo process as much as we can in the area of special education law. So I'm not going to take questions during this presentation. I'm going to go ahead and go through the information. Then we're going to take a 15-minute break somewhere around 2 hours from now, and take our breaths, breathe deeply, and then do a Q&A session for about 30 minutes. So if you have any questions along the way, please note those so that we can talk about them in our 30-minute Q&A session afterwards. So I'm looking really, really forward to this, and hopefully that it won't blow your mind too much as I'm moving through this material as rapidly as I can. So these tips are all what I view hopefully to be practical tips for you that you can use in your own training of staff. I hope that you will. I get lots of folks telling me that they went in and grabbed a couple of these tips and used them to train their staff. And please feel free to use my materials in any way that you find that they are helpful to you. Again, hopefully they're from a practical perspective and they don't sound too much legal. Of course, though, all of this is based on my legal experience. And we're going to start kind of what I say from A and move to Z, beginning with the overall special education process and what we all call child fine, and what the law refers to child fine, which covers that scope of referral to placement, anything in between, but generally to eligibility. And then I'll move to IEP development tips, then we'll move to placement tips, then we'll move to things like least restrictive environment, ESY, discipline. I've even thrown in a little 504 in here, and for good measure, we couldn't, I guess, avoid the need to talk a little bit about COVID. I have some COVID tips, and then to finish it on out, I have some sort of what I might call mental health attitudinal tips, not mental health as it relates to students, but your mental health as a special education director. I will tell you that I have found in my experience that being a special education director for all of you is sometimes a thankless job, I know, and probably as difficult as it's ever been this past year. So I applaud you. I applaud you just being here on a Monday morning with me. Appreciate you very much. All right, so let's go ahead now then and get going. And if you're following along with the handout, I'll be referring to certain pages. certain information that's on each of these pages. My PowerPoint presentation is really just something in addition to you having to look at me. So it's just keep us on track. If you should doze off this morning at some point, I don't know how that's possible because everything I have to say is completely riveting. But if you should doze off, I have the tip up on the screen and you can find it in the handout and be right where you need to be. All right. Okay, so let's go ahead then and get this party started. And hopefully, well, let's see. For some reason, my slides don't want to move. Ah, there we go. So let's start off with our child find and overall identification tips. Starting with what is generically known across the country, oftentimes as RTI, response to intervention. If I recall correctly, I think you guys in Mississippi refer to it as the multi-tiered system of supports. I could be wrong about that, and it could actually be something that school districts call different things. Here in Alabama, school districts, some of them are still thinking about RTI, whereas some of them actually have it clearly in place. But as part of that, you've got your problem solving teams. Or your teacher support teams. You know, I find different lingo across the country. So that's what I mean by that. And we want to make sure that those who serve, particularly on problem solving teams, but everybody within the district understands that, and we want to train them to understand that that whole overall problem solving team process needs to be taken seriously. And that the role of our teams is not to get a student. I'll tell you, when I started this process of representing school districts in special education 35 years ago, we had in Georgia, where I got my start, what was called the student support team. And I would talk to members of student support teams, and really what they thought was, this is all the stuff we have to do to get this child into special ed. And I was like, ooh, no. We need to retrain everybody to think about it as a way, hopefully, to never get there in the first place. Because if it's a self-fulfilling prophecy, then we are over referring students. And that's what nationwide, particularly in the South, student support team in Georgia, building-based student support team in Alabama, all got started because students who were minorities were being over-referred for special education services. So these team processes were pretty much mandated even in federal court litigation. So in your materials on page 1, I have at least 3 bullet points there that exhibit at least 3 good reasons why we would engage in such problem-solving team process, whether RTI was all the rage or not. Number 1, to prevent disproportionality and overrepresentation based on race or ethnicity, to prevent over-identification of students in special ed generally, which is something the US DOE monitors, which in turn then state departments of ed monitor to make sure that school districts are not over-identifying students as students with disabilities. And finally, to ensure that students are provided first with appropriate instruction before being considered or referred for special education. So those are at least 3 federal reasons why we would be engaging in a serious problem-solving team process, even if RTI were not sweeping the framework for or through which we are identifying students' abilities. Number 2, overall, and I am a big supporter of training, obviously. I think it's important to train all school personnel on the overall legal requirements that apply to the identification and education of students with disabilities. And not that educators need to be experts in the law. I mean, that's what school attorneys are for, right? But having a good overview and a general understanding and knowledge of all the applicable laws relative to educating students with disabilities. And I've bulleted those out for you. I'm sure all of you are familiar with those. But of course, we start with IDEA, and I always like to remind our special ed teachers that IDEA does not stand for I do enough already, although they certainly probably feel that way often. But IDEA, and then we have the 2 Americans with Disabilities Act and Section 504, which are sister statutes that prevent discrimination overall, and generally all of our IDEA kids are covered. by Section 504 in the ADA, cannot be discriminated against based on disability. We have our Family Educational Rights and Privacy Act, or FERPA. And interestingly enough, I get lots and lots of questions presented under FERPA, probably because the nature of the personally identifiable information contained in the records of our students with disabilities is of a more sensitive nature. And so I get lots and lots of questions and do lots and lots of workshops on FERPA. Then we have, of course, formerly known as the No Child Left Behind Act, now known as the Every Student Succeeds Act. Don't know what the new administration might do with it, but certainly it has a place in educating students with disabilities, though I do hope that next time around, students with disabilities will have more room at the table when they are putting any amendments into place of the ESSA. And then, of course, Mississippi law. Your state law sometimes goes over and above or may differ from federal, and obviously you need to train folks with respect to your state requirements as well. Number 3, still in the area of early child find, ensure that if and when developing and implementing an overall RTI framework or approach to child find and identification, that parent requests for evaluation are not met with the following kind of statement. Well, I am so sorry, Ms. Jones, but we can't do an evaluation right now because your child hasn't completed the RTI process or the MTSS. 8 to 12 weeks of interventions we've got to do before we can refer your child. And this, I remember, was a fear of mine early on with the RTI approach, which was first mentioned in IDEA when it was reauthorized in 2004. So many of you may remember that. I can't believe it's been that long since we've had IDEA amendments, but RTI was one of the new things that was presented back then. And by 2011, the Department of Education was concerned. So at the bottom of page 1, if you're following along in the handout, you will see that there is a memo that I cite there to the state directors of special education that came from the U.S. Department of Ed's OSEP, the Office for Special Ed Programs. And by 2011, they were concerned because they had heard so much from parents across the country that although there was this RTI approach and framework being utilized more increasingly so across the country, parents were asking for special education evaluations, and people were saying things like, oh, no, in our district, you have to wait 9 to 12 weeks before we can even consider referring a child. And the U.S. Department of Ed said, we think it's time to remind folks about what triggers the child find responsibility to refer a student for an evaluation. And under the law, the child find a requirement to refer and to begin the evaluation process on a timely basis. The school district has reason to suspect that a child is a child with a disability in need of services. It's not contingent on how long a student has been subjected to interventions in an RTI framework. And so that was the memo that they sent out at that time, and it made pretty major waves across the country. And I realized, yeah, what I was fearful of is correct, because RTI and the child find obligation under the IDEA started to butt heads. And so I began to do a whole lot of training with respect to that issue. But I want you to know that no matter how much training I've done, I still engage with the groups where people say, but that's what we've been told to do. We've been told we can't refer children unless we have started the RTI process and 8 weeks later have sufficient data to do something. Be real careful about that, because the legal obligation is not triggered by the level of interventions that have been received by a student. It's triggered based on suspicion. And I'm going to talk a little bit more about that in subsequent tips. Number 4, remember that school personnel can't require a student to participate in an RTI framework prior to conducting an evaluation when the student's been placed in a private school or in an outside public agency like Head Start. And in Head Start and or private schooling, they don't have in place some form of NT say, sorry, you don't have any data, we can't refer. We still have to look at all existing data to determine whether there is sufficient reason to suspect or reason to believe the child is a child with a disability in need of special ed services. And finally, stressing the importance and affirmative nature of IDEA's child find requirements, but we can't forget about our little friend 504. 504 also has child find requirements, and the Office for Civil Rights, OCR, enforces it. And they enforce it mightily. And it's very clear why I say the importance and affirmative nature of the IDEA and 504 child find requirements is the expectation pretty much is that schools will be on the lookout, quote unquote, for students for whom we should have a reason to suspect a disability or need for services, special services, either under IDEA or Section 504. You'll see a recent case that I've listed in my materials. And what I do every time before I present this information, so I always go get the most recent cases that I can find that actually support these notions. I can tell you, though, that there are tons of these. But the important part is it's an affirmative nature. We're to be on the lookout for those reasons to suspect rather than waiting for a parent, perhaps, to come in and ask for an evaluation. So to sum it all up, number 6, watch out for what I call referral red flags. What would be sufficient reason to suspect or reason to believe that a child is a child with a disability who needs potentially special services? Flags, I can tell you, and this whole overall topic usually winds up being a 2-hour presentation for me. So this is a lot of information to pack into a subset of these tips that I'm providing to you. But I do believe in giving you good takeaways. So beginning on page 3 of your materials, you'll find my most recent, what I call referral red flags checklist, that answers the question in terms of what are courts looking for and what is the Office for Civil Rights looking for when they're investigating or they're delving into a case, a child find question. And we get lots and lots of this litigation that, as in some respects, been a product of the RTI movement across the country. Because what we have seen is parent attorneys, and some of them have actually said this to me, that RTI is just an excuse for not doing timely evaluations. And the argument is these children are languishing in this process when they really need to be timely referred and evaluated for special services. So that's their position. So we see a lot of cases, and I would say maybe 35% of the cases that come into our office are cases where the parent attorney is arguing that the student was not timely referred based on a number of referral red flags, either because they were in the RTI process too long and it was unsuccessful or whatever it might be. And of course, what they're seeking as relief is usually compensatory education services and of course, their attorney's fees if they prevail. So these are pretty common cases. We see a whole lot of them in Alabama. I suspect you probably see them in Mississippi as well. And so what do courts look at in these cases? And there's so many court cases for so many years that I've been able to, over all of those years, come up with what you see beginning on page 3 and over to page 4 of my materials. And if you don't have the handout printed out, that's fine too. You can always go back to it. But you will see that I have actually created 5 areas or 5 specific categories of referral red flags. And this is all based on court decisions, OCR letters of findings, anything I can get my hands on to see, well, what combination of factors did the court rely on to find that the school district violated the IDEA's child find requirement, or in OCR's instance, the 504 requirement, which is interpreted the same way. So looking at those referral red flags, and I train on these all the time, feel free and comfortable to use these as part of your training, but I think it is really important if you're going to use them to note on page 3 that I've bolded there, important note. And the important note is Don't let people take things out of context and just pick out one of these and say, well, Julie Weatherly said every child on medication needs to be referred. That's not what I'm saying. It's in combination. If you are going through this checklist and a team is checking off a whole lot of these, particularly in the academic and behavioral, social, emotional concerns areas, then the more of these we have, the more we might want to question whether we should refer the student for an evaluation. And we don't wait for parents necessarily. So we have our own academic concerns that we see in schools, and I've listed out examples of those. None of this is all inclusive. There are certainly more, I'm sure, that we could add to these in terms of failing or noticeably declining grades, things like retention. The student negatively stands out academically. That's actually terminology I've seen used in court cases. The student has been in our problem-solving team, MTSS team process, and progress monitoring data indicate little academic progress or positive response to interventions. Can also use that data in a child find case when we're defending ourselves. We can see that the data indicates the child was responding positively. If we've got good data, and a lot of times we're seeing school districts are able to defend themselves in child find cases. So that data comes in handy when we want to defend ourselves and show actually, no, the child was responding to those interventions. Behavioral and social emotional concerns, you can see those listed there. There is a concern post-COVID that I've been reading a lot about nationally, that there has been already over referral of students for suspected disabilities, students who come back with social emotional exposure to trauma type issues and things like that. You know, we're going to need to give them some time, but we want to do that in a very consistent procedural way, organized way, so that courts and hearing officers will understand that after COVID, we need a little bit of time to let test rather than referring them immediately. And I think that we will see a lot of understanding amongst our hearing officers and judges in those kinds of cases. Then I have a category of outside information provided. I don't know what it's like for you guys in Mississippi, but we find in Alabama, my goodness, the doctors know all about special ed. Can you believe it? They prescribe IEPs, they prescribe 504 plans. I mean, wow. But what does that mean? Does that mean all this outside information coming in tells us the child must be referred? Absolutely not, but it's something to consider. So we do get a lot of outside information. We get DSM-5 diagnoses, but understand that a DSM-5 diagnosis doesn't necessarily mean a child needs to be evaluated for special ed, right? But it's one factor to consider. And if we have a whole lot of other check marks, then it might be time to go ahead and refer the child for an evaluation. Internal information amongst our own staff. I had a child find case several years ago where there were emails between staff about when in the world is this child going to be evaluated. Look at all these academic and behavioral having to go through this framework, this MTSS thing. I was like, oh, okay, well, we're burned in this one by the emails. So just a little side note, please train staff on proper emailing and what to put and what not to put in emails, because those become something that parent attorneys love to go after. And then last but not least, parent requests for evaluation services, but in conjunction with number 7, as I mentioned earlier, do not wait for parents to initiate a referral for an evaluation when sufficient red flags are present. I subscribe to a theory, and that is if we're wondering whether we should, even if the parents ask or not, we should pursue parent consent to begin an evaluation and let the parent refuse if they don't agree to that. But we don't wait necessarily for parents to initiate. Probably one of the biggest child find cases in this area is the one that I've cited there on page 4. It's out of the Ninth Circuit Court of Appeals, but I actually use it as a case study when I am training on this issue. And that is a case involving a young lady who was not evaluated by the school district until her senior year. But 10th grade, if you just look at the blurb here in these materials, you'll find about, I think the count is 8 referral red flags. So this is why I use this one. So you have a 10th grade student who's failing. So there's number 1. Referred by the school to a mental health counselor, there's number 2. The mental health counselor ultimately recommended an evaluation, there's number 3. Her teachers indicated when they testified at the hearing that her work when she did schoolwork was, quote, gibberish and incomprehensible, there's number 4. She played with dolls in class, there's number 5. She urinated on herself, there's number 6, and so forth and so on. But they waited to senior year in high school. And when the parents sued, the school district's defense was, in some respects, brilliant. The school district said, she can't sue us for anything because we haven't done anything. I thought, okay, that sounds kind of right, but not in the context of child fine. That is not a wait for the parent to ask model. It's affirmative in nature. And that's exactly what the Ninth Circuit Court of Appeals said in that case, and clearly said that they had violated the child fine requirement while waiting for the parent. One of their defenses was the parent never asked for us to do an evaluation. That doesn't work in the context of child fine, either under IDEA or Section 504. So one thing I like to train lots of school people on is number 8, refraining from diagnosing medical conditions or suggesting medications without the credentials for doing so. Unless you can validly sign your name with PhD or MD, it's very dangerous for us to pull out the DSM-5 and start talking to parents about medical conditions or suggesting medication. We're familiar with the fact that we have had case law over several years where that has been done by school staff. And just as much as we hate doctors doing that to us, we should not be doing that to them or suggesting to parents that they place their children on medication. We would like to know about that information if they have it, because it's an important factor for us to consider. But number 9, remember to refer a student back to your problem-solving teams, teacher assistant teams process if a determination is made that a student is not going to be referred for an evaluation. To finish out that procedural step, we need to send prior written notice of any refusal to conduct an evaluation. Now, these days, pretty much most districts that I work with, and of course it's district to district and it may be case by case, but most districts, if a parent is adamant that a child needs, and then fight the bigger battle of whether or not the child is eligible, which I tend to support. Again, when there's debate, evaluate. If the parent is absolutely adamant, then go ahead. But if there is absolutely no behavioral, academic concern, no reason to suspect or believe that the child is a child with a disability, the federal law gives the option of providing a refusal. But most districts in practice, and even some states, will require going forward with an evaluation when a parent asks. I generally view that if there's a question, I think we probably should go ahead and do an evaluation. And as I said, fight the bigger battle of eligibility. So let's pretend that we have decided to go forward with an evaluation. These are the evaluation and re-evaluation tips. Number 10, exercise the right to conduct independent evaluations, particularly in cases that we see the potential to be adversarial. And we want to conduct those evaluations by professionals or experts of our choosing for purposes of determining eligibility. Now, sometimes parents will come in with perfectly valid evaluation reports that a school district might decide to use, or they come in with something from Syracuse or somewhere else that says all kinds of things that we don't see with respect to that particular student. And if we see something becoming potentially adversarial, know that the law is long-standing law, and all of the circuit courts have agreed that if indeed a parent is asking for services or something from the district clearly has not only the duty to conduct an evaluation, but the right to conduct an evaluation. And so we have seen often school districts responding, hey, we'll consider these evaluation reports you've brought in, but we want to do our own by our own professionals or maybe even outside professionals. And the Fifth Circuit Court of Appeals, which is your Court of Appeals, has the Shelby case. The 11th Circuit, which is my Circuit Court of Appeals, Alabama, Georgia, and Florida. We're kind of sister circuits, the 11th and the 5th, and both of them are school districts clearly have the right to conduct expert evaluations by experts of their own choosing and not have to go with just what the parents brought in. Number 11, share fully all relevant evaluative and other educational information about the student with the parents. There is a lot of, as you well know, there are a lot of procedural aspects with respect to parent involvement and meaningful parent participation in decision making. And so when we are offering up the results of our evaluations, we may want to make sure to explain those properly to parents, make sure that they understand that information. I always like to say, and please not use other things with parents. This is a really important thing to afford them meaningful and informed participation. But it is important to really put all cards on the table, face up, good, bad, or ugly, and make sure that parents clearly are meaningful participants, that they're informed and understand about what the evaluative information shows. And there are a couple of cases that are well known that I have cited there in your materials to support that notion. And the ones that I cite in my materials are not the only ones. They're just either nationally known cases that have discussed these propositions or very recent cases. Number 12, refrain from suggesting to parents that they're the ones responsible for obtaining any educationally relevant evaluations, including, believe it or not, diagnostic and evaluative purposes. This happens a good bit with staff, and I've heard many times over many years in cases where we haven't done an evaluation. I'll sit down with folks and say, so what are we waiting for? And the response is, we're waiting for the parents to bring in the evaluation report from the doctor. I'm like, how long have we been waiting on that? Oh, about 6 months. We told them 6 months ago in this meeting that we're waiting for it. And we're waiting for it because it's educationally relevant, right? And that's when I get nervous that it's the school district's responsibility to conduct those evaluations. The Office for Civil Rights has even suggested that we can't even ask parents to bring in medical evaluations to make decisions under 504. And I think that's going a little too far. I think we can certainly ask them if they have them, but if we make it a responsibility on the part of the parents and all action ceases on the part of the school waiting for the parents, then it becomes a problem. We've delegated the obligation to conduct the evaluation to the parents. So at the bottom of page 5, a nationally known case, the MB case, the school district, the Hellgate Elementary School District. And I'm always thinking to myself, the kids waking up in the morning, I don't want to go to Hellgate again. Mama, please don't make me. But in any event, I think that's humorous. But I'm thinking that the assistant principal involved in this case was looking at Hell's Gate when he read this opinion when it came out, because he was the LEA representative at the IEP team meeting. And when the parents at the meeting mentioned that the student had been diagnosed with autism several years before, the assistant principal said, well, maybe you need to go out and get that updated. And as soon as you do, we can take a look at that. But for now, we're going to make our recommendations based on what we have. And the court said, no, it's up to the team to have done a full comprehensive evaluation. If there are other evaluations that need to be done, you can't send the parents out to get it. But it was one of those, yeah, just go out and get that. Let us know when you get it, and we'll take a look at it, and then we'll make further recommendations. If it was necessary, then it needed to be done by the school. So said the Ninth Circuit Court of Appeals. Number 13, use a variety of assessments when evaluating for the existence of a disability, and don't use a single assessment to identify a disability. This is one that is a biggie. in terms of making sure we do full comprehensive evaluations and not rely on single assessments such as an IQ score, as they did in the very famous Draper case from the Atlanta Public School System, the 11th Circuit Court of Appeals, where they based all of their recommendations and everything just on an IQ score, misidentifying the student for many, many years as quote unquote mentally retarded at the time versus specific learning disability. So that case got a lot of traction and continues to get a lot of traction over the years. Full comprehensive evaluations. And we want to make sure, as number 14 says, to conduct those in a way that evaluates the student in all suspected areas of need, not just disability. Sometimes I find a danger in a referral for an evaluation that is very restricted in terms of what's going to be looked at, because it's almost a predetermination that we're going to do this kind of evaluation because this is the disability category we're looking at, rather than ensuring that students are evaluated also in all areas of suspected need, not just suspected disability. So there have been many cases over the years, such as the ZB case, where there were other weaknesses that weren't looked into. Oftentimes we'll see a situation, for instance, where we have a speech-only child who has lots of issues in the area of behavior, attention behaviors or conduct problems, and we're not evaluating in all suspected areas of need. So just a reminder there to share with your staff. Number 15, make appropriate and thorough conduct reevaluations when warranted, and presume that a reevaluation is needed rather than presuming that it's not. So this is one that I added because I've been around for a long time. And I have been through every amendment and reauthorization to what was called Public Law 94-142, now IDEA. And in 1997, changed significantly. And some of you may have been around during that time. When I am live with folks, I like to look at the audience and see if I see any heads shaking like this, because it's important to me that there are heads shaking like this, because when there are no more heads, when people are looking at me like, what is she talking about? I'm probably going to take that as a sign of time to go. It's time for me to sail off into the sunset. But till then, I still see heads that go up and down, and where reevaluation prior to 1997 under the law was a requirement that we would reassess formally all students who were identified, to re-identify them with pretty much the same evaluations that we did to make them eligible in the first place. They all had to be redone. Then the notion started of, why is that necessary? There are some children who obviously don't need to be formally reevaluated to continue their eligibility. So now every 3 years we are to meet to determine whether needed to continue eligibility. But for some reason, when that started, what I started to see was a lot of teams just going, nah, we don't need anything else, do we? When there might have been a lot of changes that have occurred with respect to the needs of that child. I would rather, and I've seen so many cases where courts have school districts for not re-looking at things, particularly when warranted, when the needs of the student have changed. So reevaluations, we need to remember, need to be warranted. And every 3 years, we ought to really be delving into, do we need to conduct or gather any formal assessment data in order to properly serve this child, rather than just defaulting to the, we don't have to, so let's don't. I have unfortunately with data, evaluative data included that's 6 to 10 years old, cited in the IEP. And I think that can get pretty dangerous. We want to be sure that we are reevaluating as warranted. Number 16, consider the results of those private evaluations. I talked about all the doctors who are so forth. What do we do with those when parents bring them in? We are to consider that information. Consider being the operative word. Consider does not by any means mean that we adopt those recommendations. Rather, it means we are to consider that information for what it's worth in light of the data that we know about the child. Oftentimes, I find private evaluators sit with a parent for 5 minutes and just write what for. So the level of consideration we give to it may be different, but we still want to consider that information again for what it's worth. And you will see a couple of cases that I've cited there, some fairly recent cases. The Mark M case is my go-to case. I use it a lot in training, where the LEA representative and assistant the IEP team meeting took the parent's private report and said, well, thank you for providing this too late in the afternoon. If you wanted us to consider it, you should have brought it to our attention at the beginning of the meeting. Since it's too late, we don't have time to do it. Therefore, we're not going to. And here are our recommendations. And the court ruled in this Mark M case, the court ruled that that in and of itself was a procedural violation in terms of ignoring parental input and not considering the private information that they brought to the table. So we don't want to mark M it. We want to make sure we consider that information. Now in 2020, could that LEA representative had said, yeah, well, it's a little late. We don't have, you know, we're gosh, it's getting late in the day. Can we adjourn and then get back together and reconsider this information and talk about it? Then yeah, that would probably be the way to go. Number 17, remember that parents have the right to request what the law refers to as an independent educational evaluation, or IEE, and that is at public expense when they disagree with the evaluation that the school district has. Of course, we want to respond appropriately to these requests. So I work with a lot of special ed directors. We're always updating their IEE policies and procedures, their qualified lists of examiners, all of those kinds of things that go along with IEE. And we certainly want to train folks on how to respond. It is not an IEP team decision. So we'll ask for an IEE and the IEP team says, no, we've already done our evaluation. We need to train folks. The easy answer is, let me refer you to our special education director who will make the decision about whether or not the district will fund an IEE. Simple answer, rather than having staff out there trying to explain the procedural safe respond to a request for an IEE. All right, number 18, the qualified list of examiners. I put that one in here individually just so that we remind ourselves that we also need to not only maintain it, but update it in terms of our list of criteria, list of names of independent qualified examiners. And we can include, according to the US DOE and court cases, reasonable costs. There have been numerous cases over many years where a school district has requested a due process hearing in response to an IEE request because the parent's request of a particular examiner is too costly. And the school district's list is reasonable, and we can get an evaluation for half of what the parent's expert is asking it for going outside of what is reasonable. And on page 18, favorite cases of 2020 is the CP case. I'm getting a message that my internet connection is unstable. Are you guys okay? Can everyone hear me all right? I hope so.
Yes, ma'am.
All right, thank you. Just wanted to check in. I was wondering if it's actually a message that I'm unstable, which
it was skipping a little bit, but okay. But I think you're still pretty good.
Okay. I always hate to see that message, but I also wonder if it's me being unstable rather than the internet. But one of my all-time favorite cases of 2020, and yes, during 2020, I had to keep up with all these cases, is the one I've listed there on page 8 of your materials, the CP case, where the school district challenged the parent's request for an IEE by requesting a hearing, saying that the parent was seeking more than twice what it typically would cost to do a couple of evaluations, psychological evaluations. The parent was asking for $5,200, and the district's position was, we can get each one of them for $900. So this goes up to a federal judge in New Jersey who is looking at this and ultimately ruled in favor of the school district with respect to this issue, because the district's cap on costs was reasonable. But it's interesting, if you look at this blurb that describes in my materials on page 8 what this court said, there's a quote at the end, and this quote is right spot on. And it's very unusual I see a court that actually knows what's going on with special ed litigation. The court said, quote, "This is a federal court litigation with both parties represented by counsel over the sum of $5,000, or at least the portion of that amount that might be deemed excessive, or at least the procedures by which the parties argued about it. Though it makes no difference to the result, I observe that the secret headwaters of this flowing stream of issues seem to be underlying disputes about attorney's fees." And I will just say to you, after 3.5 decades of working in this area, sometimes that's what the special ed litigation is all about, is paying the attorney's fees. School districts often try to settle these cases very, very quickly, and we can't get out of them because the parent's attorney says they've got $20,000 in it already, and they will not settle the case, even though the district is willing to do everything the parent has asked for from the get-go. And I hate that. And I have let everybody in Washington know how I think this is a terrible way to actually resolve issues for students with disabilities. Problem is, it doesn't really matter what I think, it's what the law contemplates. And unless that changes, we still continue to have that. But I thought it was interesting that a court actually pointed out that that was really why over the amount of those IEEs. Number 19, remember the responsibility to conduct a FAPE evaluation of resident students upon request, even where the student's been placed by the parent in a private school located in another jurisdiction. This one has sparked a couple of recent cases. So this is a new tip that I added to my 90 tips. I probably took another one out and substituted this for it because I'm getting a lot of questions about this. And this is the only one I call the triple PSS children, the parentally placed private school students, that causes a lot of special ed directors some consternation in terms of how do we deal with this, particularly if you have a lot of private schools in your jurisdiction, and then you are providing the proportionate share of monies to go to parentally placed private school students to select what services you will be providing via services plans. And one interesting thing that's happening is parents placing their children in that private school setting, but then deciding, maybe this is not so great after all, and I want my child evaluated by the school district of residence, the one that's responsible for FAPE. But the school district of residence, knowing that the child is in a private setting in another district, says, well, if you re-enroll your child in public school, we'll be happy to conduct a FAPE evaluation. And what courts are saying, the Bellflower case, the AB case, no, you can't make FAPE evaluations contingent on enrollment. You're required to evaluate and do FAPE evaluations of your residents. Residency triggers the responsibility for FAPE, not enrollment in a public school in these instances. So that one has become a really hot topic lately, and I wanted to make sure that I included a tip on that. Number 20, obviously, we want to comply with applicable evaluation timelines and appropriately document our compliance with them. Generally, most states across the country have a derivative of the 60-day requirement. I'm not exactly sure I remember what Mississippi's requirement is, but states are all pretty different about what triggers the timeline, how to count the days, and whether it's school days, calendar days, or whatever. But the bottom line is make sure that you are complying with those timelines. I had a lawyer for a family years ago tell me that the timeline issue for evaluation completion from his perspective was like shooting fish in a barrel. They were so easy to get because he saw so many untimely evaluations, and he would run in and seek compensatory education. So that's just one of those, we need to have good procedures in place for ensuring timely evaluations. So now let's move to our eligibility tips. Number 21, please adhere to your applicable state eligibility requirements, including all the definitions, the criteria, the minimally required evaluations, and make sure your documentation adheres to your state requirements. I work with lots of state departments of ed, and they tell me all the time, it's just a simple matter of actually making sure that on the forms that people are completing them appropriately because they track state evaluative criteria. So making sure that we train folks to be sure that we put our best foot forward when state monitors come. Number 22, use an appropriate eligibility committee or team process with required participants, including the parents. Now, this one I probably don't need to remind you of, but again, if you've been around as long as I have, some of you might remember the days where we could determine eligibility in a team process without inviting the parents. But the law was changed in 1997 that parents are to be participants in all decision-making, including eligibility. But I used to find it so weird, and when a team would welcome the parent to the first meeting, by the way, we found your child eligible. And here's what we want to do in terms of recommending an IEP. So it was really interesting. And there are a couple of cases from time to time that come up, such as the one that's below, where in 23, where there was a situation of emailing prior to the eligibility meeting and parents were not given meaningful participation. So we need to be careful of predetermination overall, but also not predetermining eligibility. I have, again, unfortunately, seen emails where people were discussing, well, what's going to happen at that upcoming meeting? What is your data? Where is it steering you? And the school psychologist says, oh, he's eligible. It's clear this child has SLD. So everybody, let's just be on board with that and let's go forward with it. That could be considered a form of predetermination. And it's not just placement, it's predetermination of eligibility we need to be careful about. Number 24, remember that the actual disability label really doesn't matter legally. It's eligibility for services and the provision of FAPE that actually matter. And this one comes up a lot in case law when I'm talking about eligibility case law from year to year as I try to keep up with the decisions that are issued by courts. And courts have over and over said in many, many cases where the parent is adamant that their child has a particular label. For instance, the one that we see most popular is autism, where the parent is saying, my child has autism. I'm not accepting that label of emotional disturbance that you guys have found my child eligible for. I want autism, or, you know, you name it. We've had all kinds of those cases where the parent is adamant that dyslexia has not been written into the IEP. Autism, those are the ones that we see often. But when push comes to shove, what courts say is legally what matters is what's in that IEP. Is the IEP appropriate to meet the needs of the student? The label doesn't matter. There was one case out of Texas years ago where the court noted that the parent wanted the autism label merely because she saw that that would provide other benefits and things from the state and that kind of thing. And while it might have been true, the court said, we don't really care from a legal perspective. The label doesn't matter unless it actually does matter. If indeed a team member says, sorry, the child has to be autistic to get that, that would be a problem if the child needs it. So certainly we don't want to determine services based on label either. All right, let's look at our next one, number 25. So when we're looking at eligibility, at least in my mind, I've always seen from a legal perspective and reading all the case law across the country that eligibility is 3 prongs. That eligibility teams will look at number 1, based on the evaluation data, whether there is a condition that does exist under state rules, whether it's SLD, autism, IND, whatever it might be, OHI, so forth and so on. There's a condition, number 1. Number 2, that adversely affects educational performance. And number 3, to the degree the child actually needs special education services. And so courts tease out those 3, and depending the circumstances are, they will focus on one of those. So number 25, when looking at that second prong in terms of adversely affects educational performance, we want to make sure that our teams don't construe educational performance too narrowly and saying that it's academic only, because educational performance has been deemed to include by many courts, and except the Second Circuit Court of Appeals, but that's not you guys, that's in New York and Connecticut, that area of the country. But educational performance has been social emotional issues, communication issues, and so forth and so on. So it's not just all about how the student does academically. In the most recent case, 2020, out of the 8th Circuit Court of Appeals, it is one that we see very often where a student is a mess emotionally, but actually is brilliant, maybe even gifted, and performs very well when at school. But in this particular case, the court said, yeah, but it's rare occasions that she's at school and she is falling further and further behind. Yes, she can do the work. She can outperform everybody when she is at school, but rare days she can even get out of bed because of her emotional difficulties. So to take the position, well, her grades are so good and she outperforms everybody academically is not the way we want to go when we're looking at that piece of whether there's adverse effect on educational performance. Number 26, also remembering that third prong for determining eligibility, and that is whether the student actually needs special ed and related services. Does the student's condition adversely affect so much so that the child actually needs special education services to be successful in the general curriculum? That's the question. And most of the eligibility challenges in courts these days are based on this one, where the team has decided we just don't believe the child is eligible, but the parent is adamant that they want an IEP. One of my very last due process hearings, I don't handle due process hearings anymore. My much younger law partner handles them. I paid my dues in those, and now I do what I like doing, and that's things like this. And way back when, that 19-day due process hearing was all about a young lady who clearly had Asperger's syndrome. No doubt about it. Everyone agreed. It clearly adversely affected her educational performance from the social perspective, but she was blowing the lid off of all of the academics. But her parents felt like an IEP would actually guarantee that she would get into any college that she wanted to get into. And they were adamant then that she was eligible. And my district took the position that if she's eligible, then we have a whole lot of other children who are eligible as well. So in any event, we prevailed in that litigation, but it was all about this third prong. Did the student need special education and related services? So the Fifth Circuit Court of Appeals in this 2019 case that I cite, but actually 20 decision, deals with another category that we see a lot of, and that's dyslexia. And that condition of dyslexia and whether there is automatic eligibility. And I don't know if in Mississippi you're seeing a lot of those arguments. In Alabama, we certainly are. And dyslexia is growing across the country nationally as an interest of state legislators. And we're seeing a lot of state legislation with respect to dyslexia. And so where do those kids fit in? It's kind of like what we were dealing with in the late 80s and the early 90s, ADHD diagnosis. The diagnosis doesn't really to do full comprehensive evaluations to determine whether the child just needs gen ed interventions through an MTSS framework if they're having difficulty. Maybe they need some 504 accommodations to ensure that they get specialized accommodations, or in some cases, maybe they do need special education. It depends on the student. So that's the big issue right now. And the William V case fleshed that out. And in fact, the Fifth Circuit Court of Appeals sent the case back down to the federal judge, the original federal judge, and said, you didn't do your job. Dyslexia and that diagnosis equate to eligibility. You now have to determine whether the child needs special ed services. So it's a really interesting case that sort of brought dyslexia to that forefront as well in terms of eligibility. Number 27, distinguish between SED and BAD, but be careful and thorough in doing so. Yeah, we all know that we have some students who misbehave that really don't have a disability that they can pin that on, or that we can pin that on, but it's really difficult to sort out that social maladjustment versus SED thing. And for many, many years, school districts struggled on how to do that. And sometimes it's very, very difficult to do so, but we know it can be done because there are court decisions where the school district has determined that the child was BAD, not emotionally disturbed or disabled, and the court agreed. So we know it can be done. It's just tough to do so. That's an hour-long workshop in and of itself to go through all that case law, but just make sure you have a good coordinated way of doing that if you're going to go that route. Number 28, don't rely solely on medical diagnoses or recommendations for determining eligibility. Parents sometimes want that to happen, and clearly that is not what we do. We do not rely on just what the doctor says for determining eligibility for special ed. In fact, we can't. And we need to tell doctors who are doing that, that we have a method that has to be used to determine eligibility appropriately under IDEA. The Marshall Joint case that I've listed there on page 11 is my go-to case. I used to use it all the time in our eligibility cases, where, and toward the end of the blurb there, if you've got the handout, you can see a quote that has been used by courts ever since. Quote, a physician cannot simply prescribe special education. Rather, the IDEA dictates a full review by an IEP team. So that has been quoted by other courts. In fact, the MG case in 2008 used that same quote from the Seventh Circuit. So it's the Sixth Circuit quoting the Seventh Circuit. My guess is your Fifth Circuit would also quote it, and our 11th Circuit as well. The doctor's statement is the place to start, but it is not the ultimate conclusion. I was years ago working for a school district that had several doctors in the community that would just pretty much write whatever it was the parent wanted to, and the parents would then bring it to the school. And as soon as the school said, well, we have a procedure we have to use, that was heard by the parent as, no, we're not doing that. And it started the adversarial relationship. So the school district special ed director contacted those doctors' offices and said, would you mind if we had a little meeting and connected and talk to you guys about this and do like a little workshop on eligibility for special education in 504. Would you be willing to do that? And they were. And I went to that meeting and we did a little mini workshop for those physicians who actually apologized afterwards, not realizing the adversarial relationships they were doing that, and then take it to the school and they should do whatever you want to do. They finally understood what school districts are required to do. And it really helped a lot in that particular community in those particular situations. Number 29, moving in now to IEP development and FAPE tips. So we have found the child eligible. Now we're moving into developing an IEP and providing free appropriate public education. So let's talk about these. Number 29, be aware that the IEP is considered to be, as the Supreme Court has called it, the centerpiece of the IDEA's educational delivery system for students with disabilities. Other words, one other Supreme Court decision actually called it the modus operandi for getting the FAPE job done. So what is in the four corners of our IEP, the four corners of that document, essentially is what courts will be looking at when there is a challenge as to whether or not the student has been provided a free appropriate public education. And of course, there I cite the Andrew F. decision, which we all know is the most recent Supreme Court weigh-in on what is a free appropriate public education. And I think we're all hopefully pretty familiar with and have trained our the language that we need to use. And that is whether an IEP is reasonably calculated to enable a child to make progress in light of the child's circumstances. So now I think I'm hearing somebody who's not muted. And you probably don't want us to hear your conversation. So I don't know if any of the co-hosts can check and see if we can mute that person.
I'm checking now.
Okay. I just didn't want that person to not realize that, because I wound up being on one last week, I think, and I accidentally unmuted myself and I didn't know I had done that. They were like, Julie, we don't want to hear your conversation. Or you don't want us to hear your conversation. All right, so starting with that language from Andrew then is how we examine our IEPs and how we examine the FAPE standard in all of our cases. So let's look at number 30. When we are in the IEP development process, the number one procedural issue that we want to make sure we train people to avoid is predetermination of placement. Or in other words, any action that appears to deny parent input into the educational decision-making process when developing the IEP.
Hold on one moment. If you're unmuted, please mute yourself.
Hey, Bobby.
Yes, ma'am. Yes, Kimberly.
She muted herself. I put it in the chat box.
Thank you.
Excellent. Thank you so much, Bobby. Thank you. I didn't know if it was my unstable internet or if it was someone talking. All right, so predetermination of placement is what I call, when I am training in Hawaii, and oh gosh darn, somebody has to train in Hawaii. I call it the big kahuna of procedural mistakes. And the reason I do so is all of the circuit courts, every single one of them, has decided that you could have a beautiful IEP, but if there is evidence that the team in developing it predetermined placement, that in and of itself constitutes a denial of FAPE. So we want to make sure that we do really good training for all of our staff to stay far, far away from predetermination. And as we well know, and I have cited in the materials, the 2004 IDEA amendments talked about procedural violations and the fact that not all of them are automatically, the failure to dot some I's and cross some T's in an IEP is not automatically a denial of FAPE. But where that procedural problem significantly impeded the parent's opportunity to participate, and I have bolded that there on page 12 of the materials, that is considered predetermination, and that in and of itself will denial of FAPE. One of my all-time favorite cases in this regard is the Spielberg case, and I guess it's my favorite because it involved the attorney for the school district that wrote a letter to the attorney for the family that said something like, "This is to remind you we're going to be having that. I want to give you a heads up. The school folks have already met and they've decided that the child's program will be program X and will not be any other option. Sincerely yours, see you next week." And the thing that you don't want to ever have happen as a school attorney is what happened here. The letter became exhibit 1 for the parents in that case. So much so that the court actually quoted the letter word for word in its order, ordering the school board to pay for private school for the student, noting that the lawyer's letter clearly reflected that school staff had met ahead of time, and therefore the parents were denied meaningful input. So it really didn't matter what program X looked like. In fact, the school attorney actually argued that program X was a wonderful program for the child, and that's what the court should be looking at. And the Fourth Circuit Court of Appeals said, no, we don't care about program X because the school staff committed the fundamental sin of predetermination. Years ago, was doing a workshop out for the National School Boards Association Council of School Attorneys, and this fella came up to me afterwards and he said, that was me that wrote that letter in the Spielberg case. I said something very Southern like, well, bless your heart, sweetie. But how was he to know that in the strange land of special ed law, you can exalt process over content, and process can sometimes win the day or lose the day for the school district if we have a procedural violation that is a harmful procedural violation, such as predetermination. All right, let's move to number 31. Move my hand. I don't know why. Drafts of IEPs and or meeting notes that reflect changes that were made to the IEP based on that parent input. I have put in your materials at the bottom of page 12 and over to page 13, some case law that included courts turning to the drafts of IEPs and or meeting notes. I am a big believer in IEP meeting notes or some sort of conference record that reflect just in bullet points, key items that were discussed during the meeting. And drafts can come in handy too if you have a draft ahead of time. Now, drafts are not illegal. I feel like drafts are perfectly fine as long as parents are made aware that it is a draft for discussion purposes only. But it's handy sometimes to have that initial draft and then the ultimate final product, because many courts will sit them side by side and say, clearly, there were changes made that reflect parent input. Some of the recommendations that the parents made were incorporated into the IEP. So either meeting notes, kept drafts, those kinds of things, just think about it because there are a lot of cases that reflect the importance of those. Number 32, while predetermination we want to avoid it at all costs, we also want to prepare adequately for IEP meetings. Now, nothing under the law says that school folks need to prepare for IEP meetings, but I'm here to tell you that it is fundamentally necessary for folks to be somewhat prepared for IEP meetings for no other reason than it is a much better look than not being prepared. And I always worry about that attorney sitting across the table. And of course, I've only attended IEP meetings in the past when parents bring their attorneys, but they're looking for unprepared people. They're hoping for unprepared people. I like to look like we got it going on. So we prepare with checklists and those kinds of things, but avoiding predetermination. We want to look very prepared. I worry even more about the parent's perception. If the parent sees an unprepared group of professionals, the parent may be thinking, well, my goodness, if they're not even prepared for this meeting, what must my child's day look like? So those are really important things to think about, and having good preparation strategies in place for IEP meetings. Number 33, be sure to act reasonably in response to parent requests to reschedule IEP meetings, particularly if their request is for legitimate reasons. Sometimes it's not. And that would be reflected in the AL case at the bottom of page 13, where the parent canceled 4 times. And it was, the court said, okay then for the school to have documented their attempts and go forward at the 4th time. The Doug C. case was a case where the parent asked for medical reasons to postpone a meeting to later in the week because the parent had a doctor's appointment and really wanted to go to the meeting and just said, can we reschedule it for later in the week? Problem was, the school folks had scheduled the meeting on the last day they could do it to meet the annual review requirement. Moral of the story is, do a better job with scheduling IEP meetings, of course, but bottom line in this particular case is they decided, because they would get dinged by the State Department and monitoring, they decided to go forward with the meeting without the father. And the Ninth Circuit Court of Appeals in the Doug C. case that's listed there on page 14 basically said, yeah, we understand you had 2 bad choices, school district, but you picked the wrong bad choice. That parent right to participate outweighs any monitoring responsibilities. And basically it's better to get dinged by the state than dinged by a court for denying parent input. So in any event, again, moral of the story is we do a better job with making sure that we train folks to schedule far ahead of time and not wait until we're up against our due date. Number 34, I would like to say this is an easy one, but oftentimes you'd be surprised how many court cases we've seen where the parent attorney is attacking the IEP process because the right people were not sitting at the IEP team table. So on page 14, I've actually spelled out, just to make it handy for you. I know special ed directors generally know this, but exactly who is supposed to be at an IEP meeting. And the mandatory members from the school's perspective are members 2 through 4 in that first paragraph under number 34. 2 through 4 are mandatory members, meaning that they need to be there unless they have been properly excused. And I talk about the excusal process as well in the second paragraph there. Now, I don't, in my experience, see an excusal procedure used very often. Most school districts subscribe to the theory that if everyone can't be there, we're going to adjourn. The problem with that is, what if the parent says, well, I understand Barbara Smith had an emergency, but it took me 2 weeks to get off work to be here today, or to get on this virtual meeting, or whatever it might be. I need to have it today. The U.S. Department of Ed has said that teams need to have a procedure in place to go forward to accommodate that parent. So you kind of can't win. Have an excusal procedure in place just in case, according to the US DOE. So most of the questions that I get with mandatory members relate to either the LEA representative or the regular ed teacher. And I have a case on each one of them. What I want to say about the LEA representative, that person that is supposed to meet the criteria, knowledgeable about the general curriculum, knowledgeable about the availability of resources and so forth. Don't ever appoint folks as an LEA representative if they don't know that's who they are. I have had lots of school administrators serving as LEA representatives that I'm now training who've never received any training on how to do that, thinking that LEA stands for least experienced administrator, when we all know it stands for local education agency. But believe you me, I have seen that where they really don't understand what the roles and responsibilities and criteria for serving are. So whoever is serving as an LEA representative, please let them know that's who they are and the importance of their presence. The case I've listed there, the Pitchford case, found a denial of fate based solely on the fact that there was not somebody serving properly as an LEA representative at the IEP meeting, voided the IEP that was developed because of that procedural violation, saying that it denied the parents meaningful opportunity to get information from that very important person who was not there. Then we have our regular ed teachers. And I know you probably don't have this in Mississippi, where regular ed teachers say, I don't know why I have to be there. I teach regular ed. That child just attends my PE class with the special ed teacher, or whatever it might be. Not helpful commentary particularly, but we need to train our regular ed teachers. Make sure they understand when I say proper attendance, it's not just physically being there, it's properly being a participant in that meeting and understanding their roles and responsibilities. You can see on page 15, there's a case there, the ML case that's nationally known, that found a denial of fate because a regular ed teacher was not presently at the IEP meeting, calling that failure to have the regular ed teacher there a critical structural defect because there was no teacher there, because it was a clear violation of the procedural aspects of IDEA. So we've got to remind our teachers how important it is that they be there, but not just that they properly be there. Number 35, allow parents also to bring invitees to the meeting and afford them the opportunity to participate. And that does include attorneys and advocates, even difficult ones. Not that you guys have those in Mississippi, right? But yeah, parents are entitled to bring people with knowledge or special expertise with them to the meeting. And we are to welcome them with open arms and give them a full level of participation, because that's part of parent input. So we have all kinds of different kinds of folks coming to IEP meetings, whether it's other relatives, next door neighbors, Sunday school teachers, mom's creepy boyfriend, whoever it might be. Those are one interesting thing. I'll just make a comment. We also need to have good procedures in place for determining who parents are. That's a 2-hour presentation in and of itself. The reason I know that is because I've done it. There's so many different varieties of parents, but once we've determined who the parents are, who the right parents are, we are to afford them the opportunity to bring INTs with them to the meeting. I think it's also important when they do that to identify everyone that they've brought, particularly if they are participating by phone or video conference. I have had several cases where parents have not identified who's on the other line or who's sitting in that room virtually. And you need to and have the right to find out who those invitees are. You're talking about confidential information about a child. Therefore, you have the right to determine who is in the room with you or participating by phone and what their interest in that student is. How are they knowledgeable about that child? What help can they be to the meeting? Number 37, remember that beginning not later than the IEP in effect when the student turns 16 or younger in some states, maybe yours, the IEP must contain appropriate measurable post-secondary goals that are based on age-appropriate transition assessments and so forth. If the student does not attend the meeting, please ensure that the student's transition needs and preferences are adequately assessed so that we have that information otherwise. So at the bottom of page 15, you'll see some case law with respect to that issue. The Gibson case was a case where apparently the parents, their advocate, and the school folks they had words at IEP meetings that were loud and slamming of doors and all kinds of things going on, the court pointed out. And so the team felt like it was better for the student not to attend to see all that nonsense going on. The teacher did indicate that she could have prepared the child to be there appropriately. And so bottom line was, because they didn't assess the student adequately and get the information alternatively, that ultimately denied FAPE to the student in handling that situation. So that's just one example of a scenario where they didn't have the child present. They thought their reasons were legitimate, but ultimately the court faulted them for not having alternative information in place. Number 38, make IEP recommendations and decisions based on the individual needs, the INIDEA, the INIEP, the individual needs and circumstances of the student, and nothing else. So this is a training that could also be a lengthy training in terms of things that are said that we would hope never are said at meetings, like that would cost too much. We don't have that here. The speech therapist says that, you know, my caseload won't handle that. Those kinds of things when parents and or their advocates make demands. Sometimes those are knee-jerk responses, but the problem is they are not based on the individual needs of the student, or they sound as if they are not. They sound like they're based on something else. So we have a lot of famous cases, several of which I have listed there in your materials on page 16. You want to always look like you're focused on that individual child's needs when making all recommendations. The Jefferson County Board of Education case, and this is out of the 11th Circuit, it's out of the state of Alabama, as a matter of fact. The court felt like the recommendations for that particular student were not individualized for a number of reasons. But one of the worst reasons was the fact that when they developed draft of the IEP and then finalized it, someone struck out the name of the wrong name of a student written in there and wrote in the right name. And the court just pointed out, look, this was even a cut and paste from another student's IEP. So clearly, and there were a number of other reasons the court felt like it wasn't individualized, but we want to make sure that our teams are trained very well on making individualized determinations and not saying things that make it look like they're not focused on the individual student. Avoid making IEP recommendations and decisions based solely upon cost of services. Oh, how I wish I could go to a judge and say, Your Honor, I move to dismiss this case on behalf of the school district because we're out of money. We're so sorry. We just don't have any money left to do this. And the court would say, you're right, Ms. Weatherly, case dismissed. Courts have generally never embraced costs of services. And sometimes that can be frustrating because over many years, we haven't had the money that Congress initially promised to fund IDEA adequately. We keep hearing year after year, particularly when there is a new Congress, we keep hearing that someone's taken on the task of fully funding IDEA. Maybe, just maybe we'll see it this time around. Certainly the impression that advocates and parents have these days is that school districts are very wealthy now due to all the stimulus money. To be real careful with that money because we might see some repercussions of it in the aftermath when it all tends to go away. So be real careful with that as special education directors. Number 40, use a proper process for determining what is the least restrictive environment where the student can make appropriate progress. And that really is the question. And that's really what all I want to say. You know, any of these could probably be a 30-minute to 2-hour presentation in and of themselves. The process to use is highly individualized, but the question is, what is the LRE where the student can make appropriate progress? Not what is the LRE that the parent wants, not what is the LRE that school staff want. It is place the child in the least, and what is the least restrictive environment where the child can make appropriate progress in light of the child's circumstances. We don't just dump a child in a regular class with a one-to-one aide and they're flailing and not making progress. That is not the LRE. Regular ed classroom full-time is not the LRE for every child. So we can't go with the full inclusion notion either. Bottom line, it's highly individualized. I have placed some LRE cases in your materials there. Just fairly recent ones and fairly good guidance as well from the U.S. Department of Ed. Number 42, appropriately appropriately annually the issue of ESY. Oh, I'm sorry. Yep. For every student with a disability. I just confused myself with the wrong page of the handout. So let's talk a little bit about extended school year services. You know that it is an annual and every student. Now, ESY has gotten a little bit interesting, particularly post-COVID, during COVID and post-COVID at this point in time, as we are truly beginning to get back to quote unquote normal school operations. But the obligation to make this annual determination did not cease. And we still must continue procedures and appropriate factors to determine the need for ESY, which is separate and distinct from summer services, from recovery losses, or whatever we might be calling our COVID impact services, completely different. And it's interesting too, many districts across the country aren't really having a summer break either, or the student may not have a summer break, which might make it a little bit different as well. But we still need to do it, and we still need to train teams to make the determination appropriately. Number 43, address behavioral strategies and interventions when appropriate. And of course, we have that guidance in our IEPs themselves, that question that our teams always ask, does this child have behaviors that impede the learning for that child of others? And if the answer is yes, then that means the team needs to address that, either through the performance of an FBA and the development of a behavior intervention plan, or strategies and supports listed in the IEP, through goals, through services. In some way, some form or fashion, the team must address with positive behavioral strategies and interventions that behavioral issue that has been identified. Number 44, seek the assistance of and or contract with behavioral experts. In other words, maybe board certified behavior analysts when previous efforts to address behaviors FBAs and BIPs have not been effective in enabling the student to make progress. Don't just stop with what we've been doing. If all of a sudden our tools in the tool chest are not working, we may need to seek outside assistance. And many times we have worked with districts where we have decided we needed to do that in order to make sure we are making all good faith, reasonable efforts to try to address the behavioral issues. Number 45, include appropriate statements of present levels of performance or otherwise ensure that we have adequate baseline data for measuring and generating data to reflect progress or lack thereof. I think some of our special ed teachers and other service providers miss the importance of present levels, but to me, present levels are point A. Year to get that child to point good feel for point A, how can we show progress if asked to do so? So we do need to make sure we've trained folks on appropriate statements of present levels of performance and to understand that that truly is our point A to move the child to point B and assess progress. We also want to include measurable goals and IEPs that are linked to those present levels of performances and identified challenges on the part of the student. Measurable goals being the operative language. If they're not measurable, then how are we going to be able to demonstrate progress? So we want to be able to demonstrate progress on those IEP goals. Otherwise, why do we have them if we're not measuring progress? And of course, any other relevant data that we have in general to demonstrate progress. But measurable goals, very, very important. I tell teachers all the time, if they can't tell me exactly when they're writing the goal, how they're going to measure progress on that goal, and they can't tell then the parent or the rest of the team members, then question actually measurable. Number 47, state services or amount of services with sufficient clarity in the IEP. If we're not clear, if the team uses language like to be determined or range of service week, something like that, that's not sufficiently clear according to the U.S. Department of Education for a parent to understand exactly what has been committed on the part of the school district, for them to be able then to challenge that commitment appropriately. So we want to be as clear as we possibly can with respect to the amount of services, the level of services that will be devoted to that student, and state it properly in the IEP. Number 48, we also want to be final. And we want to finalize placement recommendations for most students by the beginning of the school year, because that is a requirement under the IDEA regulations. So things happen. Sometimes we things that interfere with our ability to finalize things. COVID was one of those instances, but summer vacation sometimes can be, and all of that. But we want to make sure that for all intents and purposes, be current, in place by the beginning of the school year for every child with a disability. Now we move into IEP implementation tips, number 49. You could have the most beautiful IEP, procedurally, content-wise, everything else, but we haven't implemented it. So therefore, we have a denial of faith. Some can be helpful for ensuring proper implementation. There are loose ends at an IEP meeting at the end of that meeting that we need to tie up and sort out responsibilities for giving contact transportation. Who's going to have that meeting that the parent wants that we discussed with the principal? An action plan to make sure that everything's going to get done, including notifying folks of their responsibilities with respect to implementation. Number 50, that goes into that. Some school districts that I work with have a form for people to sign. Certainly the law is very vague in terms of how we inform all service providers of their responsibilities, but making sure that we do that and reminding them of potential consequences for failing to implement is also something that needs to happen. I have, in the last year or so, received so many requests to conduct training on failure to, and I've been kind of surprised by that, but it's just been the last year or so. And even during COVID, I did actually 3 virtual sessions for individual school districts who independently asked me, could you just come in and, for lack of a better word, scare people a little bit? And said, well, I hate to do it that way, but in a nice way, I can come up with, yeah, a lot of evolving litigation like the P.O. Trowski case that's listed there on page 21, where parents have sued under ADA and 504 for money damages as a potential remedy for intentional failure to implement either an IEP or a 504 plan. In this particular case, it was a IEP for a student with diabetes and other disabilities who was receiving supports in the context of being able to administer insulin, checking glucose levels and things like that. And the school administrators continued to discipline him for using his cell phone, which was specifically provided as a support in his IEP. So the question was, can school folks be sued for money damages, or could a school district be sued for money damages if folks do not comply with an IEP or a 504 plan? And the question is yes. In fact, there are many other cases. That's the one I chose to put in the materials, but there's even been a couple in 2021. Number 51, engage in continuous progress monitoring on IEP goals. Revise IEPs when expected progress is not being made or the goals have not been achieved, or if the goals have been achieved early in the school year, and be careful about recycling or repeating annual goals when we are developing IEPs and ultimately implementing them. Particularly in light of Andrew F. that we're all familiar with, the clarification of the standard using the terminology appropriate progress, then the expectation is that we are going to have data to reflect progress, or if we have data that reflects insufficient progress, that we engage in deciding whether we should reevaluate the situation, perhaps, and convene a meeting. It's also for teachers all the time. I tell them, please be careful not to recycle or repeat annual goals, or if you do it, be very, very careful and be able to show why exactly those are just stair steps to the next. I do see some taking objectives and making them different, but the goal remains the same. The problem that I have there, we need to think this through, is that the law references it annual goals and not 10-year goals. And so courts just don't necessarily like it too much when they see goals repeated year after year, particularly if the child's not doing well. They see it as sort of the same old, same old. So we need to make sure to train our service providers and those who write goals to be wary of that. Number 52, obviously collect appropriate data for reporting and demonstrating. I say data, I don't necessarily mean formal charts and graphs and all kinds of things, although they're helpful if we can have them as visual displays, but just every single example of movement from point A to point B. Their students have made, maybe because they don't feel like it's sufficient, but you got to look at the student's individual circumstances, and some progress for one student might actually be a lot of progress for that student or less disabled students. Number 53, avoid over-relying on grades to demonstrate progress. Certainly, while grades are something that I would throw in, if a student, I would not want to say that the child has received FAPE because the child's making all A's and B's. We have seen a couple of cases, recent cases, where courts have said that grades are not very dependable in terms of demonstrating progress because there aren't good standards in place for how people give grades, and a lot of times people are not really sure how they've decided upon giving grades because they're, certainly not objective. They're too subjective oftentimes. Now, if there are good grades, I'm going to throw them in, but certainly we're going to want significantly more to demonstrate to a court that a child has made progress. Number 54, convene an IEP. If there's any doubt about the appropriateness of or the ability to implement the provisions of the IEP. And convening an IEP meeting for all intents and purposes is a reevaluation. And I mentioned that earlier. If it looks like the child's not making sufficient progress, we don't wait until the late spring to talk about, oh yeah, he wasn't doing well in November. So, we need to convene our teams to address, make those good faith, reasonable efforts to address lack of progress if we see that through our data. So these are specific procedural safeguards tips, and you're probably looking going, she's at number 55. There's no way in time. Well, I put these in here with the expectation that I would not go through these. I mean, these pretty much talk themselves through. There's no reason for me to spend a whole lot of time on just the procedural safeguards, but oftentimes if there are folks that are new to the profession, it's just a good takeaway to be very comprehensive on what those really important procedural safeguards are. Obviously, the parent rights. I used to hear parents oftentimes say, I've been given those so many times, I could wallpaper my dining room with them. Well, you know what? We still need to give them. We need to comply there. Prior written notice in the last year or so has gotten so much attention. I would say prior written notice is another one on the top of my list of requests to do training on. I have been finding a lot of state departments of education going in and investigating state complaints and finding violations for failure to give prior written notice. So this is an important procedural safeguard. It's really to kind of let the parent know, hey, this is what we're proposing or refusing, and you can exercise that proposal or refuse. Say that was a procedural violation that itself denied FAPE. So it is a very important procedural safeguard that we need to train folks to remember to utilize and to be compliant with. We want to timely respond to parent requests to examine education. Sometimes during COVID, state complaints, and even a complaint that I saw that was filed by a parent who made requests to examine records, but schools were closed down. And what was expected was good faith out in some form or fashion. Now, we consider using IDA's mediation procedures, obviously, and it doesn't require the filing formally of a due process complaint. That was a change in the law last time around. Utilizing those resolution sessions effectively. Most of the cases that we deal with are resolved at resolution sessions. We're having still most of ours virtually, which both parents and or the school district folks and attorneys tend to like better. So we're seeing something kind of staying in place post-COVID. Gather any and all school records of the student when a due process hearing has been initiated. This is something from my personal professional perspective that I would have happen numerous times when we have due process hearings. I'd say you got to provide all of the school records, leave no stone unturned. And then even at the hearing, we would find that the parent had something that we didn't have. So any and all school records, that means any and all. And sometimes you'll find in a school that the counselor has a file, the principal has a file, the assistant principal has a file, unless it's their sole possession record. This out there, including emails. While emails may or may not be an education record, depends on what's in them, it's good for your attorney to know that they're out there, and the parent might actually have kept it, and you don't need it to come up for the first time in the due process hearing. Don't forget IDEA stay put provision, but remember that generally the school site is not necessarily placement for purposes of stay put. There are some states like California that says that change in the school building is a change of placement, but most do not. And number 62, remember that parents are entitled to an explanation of their procedural safeguards, but that doesn't mean that they can get it at the meeting. I've had cases that I felt like were somewhat harassment, where the advocate says, okay, teacher, we want you to explain all these procedural safeguards right now before the meeting starts. With someone who the advocate and parent can meet with if they have any questions and need further explanations of the procedural safeguards, but that's not going to be done. So then we have discipline. And as many of you know, when talking with a room full of school administrators, they will all agree that discipline tends to be the bane of their existence. And I know this. And I always start by telling all school administrators when I'm training them on a discipline matter, or we're just doing a workshop, I like to start with this. And I always start with it. I say to them, if you hear me say something today that makes you want to go, oh, right, then you heard me wrong. Check in with me. Let's get clarification on that issue, because there's no celebrating to be done as it relates to discipline. And it applies generally IDEA, but also to students who are 504 only plan or not. So we want to make sure we train all our disciplinarians on our procedures. And I always say that I think it all boils down to number 64 here. And I tell school administrators to think about it this way, that the concern is procedural in nature. With you making a unilateral change in placement for a student without going through the proper process. And as we all know, change of placement is the whole 10-day thing. I don't know, I remember in Mississippi, you also have some 5-day rules from an old case called the Maddie T case, but those rules and what constitutes a change of placement and what triggers the manifestation determination, they need to think through. And they need to ask, is this suspension I'm getting ready to impose going to constitute a change in placement that requires procedures? And that's where I always start with disciplinarians in my training, so that they'll understand that it's all about change of placement through the use of suspensions or other removal for disciplinary reasons. I think it's important to think about developing alternatives to suspension that would not constitute a change of placement day, including some forms of in-school suspension. On page 25, I cite the U.S. Department of Ed's long-term policy that in-school suspension is not always counted. It depends on what ISS looks like. But if it meets several criteria, such as affording the child the opportunity to continue to appropriately participate in the general curriculum, continue to receive the services on the IEP, and continue to participate with non-disabled children to the extent they would have in their current placement, then that might not necessarily count as a change of placement day for purposes of triggering the procedural requirements, including manifestation. Be careful when considering whether transportation is a related service for a student with, because that is important in the area of discipline and other areas, but most specifically here, discipline. I have the U.S. Department of Ed's longstanding position on transportation as a related service as well. If a team has decided that transportation is a related service for a child with a disability, and it's included as a related service on the IEP, then if you take it away, that's going to be a change of placement day, whether the child comes to school or not. And that is that letter to Sarzinski. So I get a lot of questions about that one, but it is really important to think it through. Is there any special transportation necessary as part of the child's disability? Or can that child just get on the bus like everybody else in the neighborhood and ride the bus? It makes a difference. Number 67, obviously want to keep appropriate and accurate data with respect to the use of suspension days and other disciplinary removals from school. I remember one of my due process hearings from hell, as I might call it, where the parent attorney had a really good charted out calendar because the parent had all kinds of good data on how many days the child had been suspended, and their count was 29. Well, this at the hearing, this is the first time I saw this. So we were kind of, again, sailing up the creek without a paddle and not being aware of the accurate data relative to the child's removals from school for disciplinary reasons. Making appropriate manifestation determinations. That's easier said than 3-hour workshop in and of itself, for sure. But one thing I can say to kind of summarize is that the conduct that led to, that was part of, and maybe even the aftermath of the incident for which the child is being suspended is very important. And if there's any indication that the student engaged in intentional, willful, premeditated behavior, oftentimes teams will find it was not a manifestation, and courts and hearing officers have typically approved that. Now, there's more to it than that, but that just kind of summarizes where we are. And the Boutel case is a prime example where the child throwing rocks out on the playground turned to another kid and picked up a big rock and says, "Hey, what do you bet I can hit that kid over here?" and then tried to blame his Tourette syndrome for it. So in any event, that's what we're seeing in recent court cases, is looking at the nature of the behavior. Number 69, remember, restraint and seclusion are not disciplinary techniques. That's really all I need to say there, but following state procedures and standards and guidelines for the use. Students who can claim that the district should have known that they were a child with a disability prior to a long-term suspension or expulsion. So this is important from a child fine perspective. Child fine violations have been used to challenge disciplinary usage. 5-day rule, make sure your disciplinarians understand that special circumstances removal provision correctly. And I do some commentary there in the middle of page 27 for your reading pleasure. Number 72, remember that the IDEA doesn't prohibit school personnel from reporting criminal behavior of a student with a disability if they would do the same for a student without disabilities who committed the same criminal behavior. 73, remember that truancy is a behavioral issue. Get lots of administrators will tell me she's not a behavior problem, she's never here. Like, well, truancy could be a behavioral issue and should be appropriately, in some circumstances, addressed by a student's IEP team. We might find in exploring it that the behavioral issue is actually that of the parent, but we need to make sure of that. Section 504, hopefully many of you special ed directors out there are not responsible for 504, and I generally prefer that special ed directors are not responsible for it, but I do know and I acknowledge that, hey, the law doesn't tell us who can do it, and sometimes within certain school districts it just makes sense for the district special ed director to also be the 504 coordinator. So bless you if that's you, but you need to make sure that you're knowledgeable and good and trained appropriately with respect to 504's ins and outs. Number 75, having good updated 504 procedures and training personnel on them is vital. Understanding that a student could be found to have a disability under 504 but not be in need of a section 504 plan is also something that's very, very important in the heart of understanding the FAPE obligations under section 504. Remembering that special rules of discipline apply to students 504 disabled only, whether they have a plan or not. Avoiding improper exclusions of otherwise qualified students with disabilities generally from extracurricular and non-academic activities, including athletics. And that includes a lot of IDEA covered kids. We have a lot of discrimination lawsuits year after year that are filed with respect to improper exclusion of students with disabilities in extracurricular, after school programs, all kinds of different things, particularly athletics, we see a lot too. Be aware that developing an individual or healthcare plan may not actually suffice by itself for purposes of determining disability and providing services under section 504. So that's another big thing OCR has been on the last several years with respect to healthcare plans and students that have those healthcare type disabilities, but maybe don't have academic issues, making sure that they're still protected against discrimination. Learning is not the only major life activity to consider when looking at 504 eligibility, or whether a child has a disability or not as well. Bullying and disability harassment is a big 504 issue. I think schools are doing a much better job these days with respect to the issue. So we're not seeing the amount of litigation that we had in past years, but we're still seeing it, where the allegation is that the school district is responsible for money damages because of known bullying that was disability related going on with respect to a child with a disability, and the child has suffered harm as a result, either physically or emotional harm. Number 82, recognize the potential for retaliation lawsuits under 504. This is a really big issue, retaliation, in terms of the protections that advocates have, whether those advocates are parents on behalf of their own children with disabilities, whether they're the student with a disability, him or herself, whether it's some other advocate, a lawyer for the family, an advocate for the family, could all bring a lawsuit if the school district takes adverse action against them for advocating on behalf of a student with a disability. The most often kinds of cases we get, I've listed 2 of them in your materials, and they are the one example of each kind. The LF case is a case brought by a parent. And lately, in the last couple of years, we've seen these cases that I call parents behaving badly, who just seem to have so much time on their hands that they can email school staff persistently, 2 in the morning, saying very ugly things, putting teachers in tears by 7:30 every morning because of these ugly emails, all those kinds of things. And school districts are having to take action when these kinds of parents are harassing school staff or showing up at the school buildings and walking down the halls and cussing out people. I know this doesn't happen in Mississippi, but hey, we have it in Alabama. So I'm just talking, should you move over here? But in any event, we can't retaliate against parents based on their advocacy, but if we are putting rules in place that they must abide by that are good, reasonable rules of civility, in terms of observing in schools, visiting schools, emailing policies, those kinds of things, then that's not retaliation on the basis of their advocacy. Courts have said, no, that's reasonable procedure to put in place for a parent who is acting badly. And we would treat any parent that way by putting a communication protocol in place, as they did in the LF case, or observation policies and procedures, school visitation policies and procedures, and so forth. So we do see a lot of parents filing, but we also see employees filing, like in the first case that I've listed there. And Pamela settled good, all right. She got herself $1 million in money damages. This is the most well-known retaliation case we have nationwide, but we have many of these cases filed year after year. We've got to be careful not to retaliate against school employees also, who may be advocating on behalf of students. In the Settlegood case, ultimately, she was saying that her children with disabilities, she was an adaptive PE teacher, were getting the short end of the stick as it related to PE activities. And ultimately, she was dismissed from her job because she was putting all of her complaints in writing. She sued because she had a husband who was a lawyer, and ultimately was paid over $1 million in money damages, mostly from the school district, but 50 grand came out of the pocket of the special ed director and 50 grand out of the pocket of the principal at the school. So it is a big issue, and I think is what kind of triggered retaliation cases from that point forward. In the last couple of years, we've gotten a lot. All right, I want to do some COVID related tips briefly. I've got 4 minutes. Understand that all of these tips continue to apply in the challenging times of COVID. Hopefully I can take these tips out soon enough, but we still have to talk about COVID, I assume. There were no IDEA part waivers or flexibilities granted by Congress or the US DOE, much to our chagrin. I did a lot of work with CASE, the Council for Administrators of Special Education, trying to get some limited flexibilities in place, but that unfortunately did not happen. So don't know how we're going to be quote unquote punished for things that were impossible to get done during COVID. We'll just have to wait and see. I think overall, and this was pre-COVID as well, but focusing on the top ways to avoid legal disputes with parents regarding any COVID-related services or anything, frankly, including compensatory services, be mindful of what I call my 4 C's: customer service, communication, collaboration, and creativity. I'm here to tell you these are my 4 C's before COVID. They are my 4 C's during and 4 C's after. You know, the best PR skills can keep parents from thinking they need to go get a lawyer or an advocate and become adversarial. Ensure your seat at every planning table when your district is planning for reopening schools and providing some COVID learning recovery services or whatever we call those. When those are underway, don't allow for plans to be made without students in the forefront. Don't let them be an afterthought. And how do we squeeze them into the overall plan? That's not how it should work. Then some miscellaneous closing tips. Avoid the temptation to unleash your inner attorney and allow your school attorney to engage in legal battles for you. You don't need to be the expert. You don't need to get in arguments at IEP meetings over what certain regulations say back and forth. I've seen special ed directors struggle with that, where they'll have their code sitting right in front of them. They, page 212, the code says so-and-so, and get in a battle with the advocate or whatever. It is not worth your time. Number 87, avoid unleashing your inner judge and don't make decisions based on inaccurate assumptions. That being said, we want facts. We want data. We make decisions based on that data always. 88, remember, sit back in some instances, take a breath. Just breathe. You've had to do that a whole lot. Sometimes you have to do it when you're dealing with a difficult situation. Don't take things personally. Never take it home, so to speak. It's not about you. Number 89, accept it. No good deed goes unpunished. I have the t-shirt. 35 years I've said this. When you know it's the wrong thing to do, but you do it to appease the parent, or you do it because it just seems like it's not worth the struggle, but it's not right for the child, no good deed. And that would be reflected with the Goleta case there in the materials. It was a case that was ultimately settled for not millions, hundreds of thousands of dollars. The special ed director was sued personally because she had agreed to change the placement of a child outside of the IEP process because the parent phoned her several times and said, you better do it or I'll sue you. And the special ed director said, we have to have an IEP meeting to do that. Parent said, I'm getting a lawyer. You better do it. I don't like that placement and you can do it. You're the special ed director. So the special ed director changed the student's placement. Parent ultimately didn't like that either. And when they were unsatisfied with that, the parent's attorney sued the school district special ed director personally, saying you intentionally violated the law when you did that. And the court actually said that you don't have to do what parents say and you shouldn't do what parents say. So they settled that case. I followed up with the lawyer who represented the district there, and I think it was like $350,000 they paid. And last but not least, and this is probably most important, take good care of yourself always. Your district can't do all this without you, and your students will not educationally survive without you. So please take good care of yourself. I know times are really tough. The summer's coming. Please take some time for you and hang in there. It's all going to be okay. So with that, I would like to thank you so much for attending this session today and allowing me to be at your quarterly meeting. Thank you for all that you are doing right now, everything that you have been doing in this incredibly challenging time. And hopefully next time I get to see you in person. I will turn it over to, I don't know, to Bobby or whomever wants to chime in at this point.